Hey Patriots, it's time to think like a lawyer. Today, we're diving into a case that has every gun owner and constitutional lawyer watching closely. It's called Reese v. ATF, and it's shaking up how far the Department of Justice, DOJ, can go when it comes to demanding information from private pro-Second Amendment organizations. Here's the deal. A federal court recently issued an order on October 7, 2025, that shocked the gun rights community. It required groups like the Firearms Policy Coalition, FPC, the Second Amendment Foundation, SAF, and the Louisiana Shooting Association, LSA, to hand over their entire membership lists to the government just to prove who's covered under a lawsuit about the federal under-21 handgun ban in 18 U.S.C. Section 922b1. Think about that for a second. The government demanding names, addresses, and affiliations of citizens, all because they joined a group that defends constitutional rights. That's not just about the Second Amendment anymore. That's a direct collision with the First Amendment, the freedom of association itself. So today, I'm breaking down exactly what happened, why it matters, and what this could mean for your constitutional rights. Legal background, the law, and precedents. Before we jump into the courtroom drama, let's set the stage with the law itself. At the heart of Reese v. ATF is a federal rule buried inside 18 U.S.C. Section 922b1. That statute makes it illegal for any federally licensed firearms dealer, FFL, to sell or transfer a handgun to anyone under the age of 21. Now, here's the twist. That same law allows those same 18, 19, and 20-year-olds to buy rifles and shotguns, just not handguns. So, what's the constitutional question? Does that age-based restriction violate the Second Amendment, which guarantees the right of the people to keep and bear arms? After the Supreme Court's decision in 2022 in New York State Rifle and Pistol Association versus Bruin, courts now use what's called the text, history, and tradition test. That means any modern gun regulation must be consistent with the historical understanding of the Second Amendment. If there's no historical precedent for a similar restriction, the law is likely unconstitutional. This standard has already reshaped dozens of gun laws across the country, from magazine limits to assault weapon bans, and Reese v. ATF is the latest battlefield. But there's another constitutional layer here, and it's not about guns. When the court ordered these organizations to turn over their member lists, it triggered concerns under the First Amendment, specifically the right to free association. Historically, the Supreme Court has ruled, in cases like NAACP v. Alabama, 1958, that the government cannot compel private organizations to reveal their membership lists, because doing so would chill participation and violate privacy rights. So Reese v. ATF isn't just about whether 20-year-olds can buy handguns. It's about whether the federal government can force political or advocacy groups to expose who supports them. And that combination, the Second Amendment colliding with the First, makes this case one of the most consequential constitutional fights of 2025. The case Reese v. ATF. Fast forward to October 7, 2025, when a federal district court initially ruled in favor of the plaintiffs, striking down the under-21 handgun sales ban as unconstitutional. But buried within that victory was a landmine. The court's order required the Second Amendment Foundation, SAF, Firearms Policy Coalition, FPC, and Louisiana Shooting Association, LSA, to turn over their members' lists to the Department of Justice by October 28, 2025. That single clause sparked immediate outrage. Within hours, gun rights advocates, privacy lawyers, and civil liberties groups condemned the order as a direct threat to the First Amendment right of association. And then something rare happened. On October 10, 2025, just 3 days later, the court vacated that portion of its ruling, effectively suspending the order to disclose membership information.
This came after a joint motion filed by both sides, yes, even the DOJ agreed, asking the court to remove the requirement. In their filing, the government admitted it did not seek to compel disclosure of the identity of members of private organizations, marking an unusual moment of alignment between the Justice Department and the very group suing it. So, as of today, that membership list order no longer has any legal effect. But make no mistake, the controversy it ignited is far from over. It raised deep constitutional questions about how far the government can go when enforcing or defending federal gun laws. The court order to disclose membership lists. When I first read the October 7, 2025 judgment, my jaw honestly dropped. Tucked deep inside the decision was a clause that demanded every plaintiff organization, the Second Amendment Foundation, SAF, Firearms Policy Coalition, FPC, and Louisiana Shooting Association, LSA, to submit to the Department of Justice, under seal, a verified list of all members as of November 6, 2020, the date the lawsuit was filed. Now, the order didn't make those names public. The lists would have been sealed, accessible only to the DOJ and the court. But even that limited disclosure raised a storm of constitutional red flags. To anyone who studies First Amendment law, forcing private advocacy groups to share their membership data with the government, sealed or not, touches the heart of freedom of association. The reaction from the gun rights community was immediate and fierce. Within hours, lawyers, journalists, and constitutional scholars started citing NAACP v. Alabama, 1958, decided 65 years ago, where the Supreme Court ruled that compelling a civil rights group to turn over its membership list, even in confidence, would chill participation and violate the First Amendment. That precedent still stands as one of the strongest shields against government intrusion into private political life. Critics of the Reese order warned that allowing the DOJ to access membership data could still create a de facto government registry of citizens who support gun rights, something Congress expressly prohibits under 18 U.S.C. Section 926A. Even though the information wouldn't be public, the very act of forcing disclosure to the government could deter people from joining such groups in the future. The backlash was swift and intense. FPC, SAF, and LSA publicly objected, calling the requirement unconstitutional and dangerous. Commentators across the political spectrum described it as a chilling throwback to Cold War-era loyalty investigations, only this time targeting advocates of the Second Amendment. By the end of that week, the controversy had exploded across social media and legal news outlets, setting the stage for one of the fastest legal reversals of the year.
The DOJ's reversal and the public reaction. Just when it seemed the controversy couldn't get any hotter, something unusual happened inside the Department of Justice. Only 3 days after the court's order, on October 10, 2025, the DOJ suddenly changed its stance. In a move that surprised nearly everyone, the government joined forces with the plaintiffs and filed a joint motion to amend the judgment before Judge Robert R. Summerhays. In that motion, both sides asked the court to strike or revise the section requiring disclosure of member lists. The DOJ's own language was striking. As a general policy, the United States does not compel disclosure of the identities of members of private organizations, and it did not seek to do so here. In other words, the government essentially admitted that the membership list requirement wasn't its idea and that it didn't want it either. That statement, combined with the joint filing, prompted Judge Summerhays to vacate the disclosure requirement later that same day, suspending any obligation for FPC, SAF, or LSA to turn over their member data. Now, legally, that reversal ended the immediate crisis. But politically, it didn't put out the fire. It only redirected it. Many gun rights advocates praised the outcome, but accused the DOJ of backpedaling under public pressure. Online forums and legal commentators speculated that the department had realized how disastrous the optics were, forcing citizen advocacy groups to hand over member data just days after claiming to be the most pro-Second Amendment DOJ ever. Still, from a constitutional standpoint, the DOJ's reversal reaffirmed an important principle, that the First Amendment's right of association protects citizens from government scrutiny of their private affiliations, even in sealed filings. It also underscored how public attention and civic outrage can influence the tempo of litigation in real time. The membership lists stayed private, but the questions raised about transparency, overreach, and trust are still echoing far beyond Judge Summerhay's courtroom in Lafayette, Louisiana. The vacatur and its broader constitutional implications. When Judge Robert R. Summerhays issued his follow-up order on October 10, 2025, he didn't just hit pause. He vacated, completely nullified the requirement that the plaintiffs disclose their membership lists. In legal terms, that means the clause is gone, erased from the judgment, as if it never existed. But even with that correction, Reese v. ATF remains one of the most consequential gun rights rulings of the year, because the main decision, declaring the federal under-21 handgun sales under 18 U.S.C. Section 922b1 unconstitutional, still stands. As of October 16, 2025, the Department of Justice has not filed an appeal of that Second Amendment ruling nor sought a stay. So, at least for now, young adults aged 18 to 21 in the Fifth Circuit can legally purchase handguns from federally licensed dealers. That's a monumental shift. It builds directly on the Supreme Court's 2022 Bruin decision, which replaced decades of interest-balancing tests with the far stricter text and history standard. Under that framework, a modern firearm restriction survives only if it's consistent with the nation's historical tradition of firearm regulation. The government failed that test here, and by choosing not to appeal, so far, the DOJ may be signaling a cautious retreat, avoiding another public loss that could set nationwide precedent if reviewed by the Supreme Court. Still, this case isn't just about guns. It's about the overlap of two fundamental liberties, the right to keep and bear arms and the right to associate privately without government intrusion. The vacatur reaffirmed the First Amendment's protective shield, while the main ruling expanded the reach of the second. From a constitutional perspective, Reese v. ATF now stands as a dual victory, one for privacy and one for the right to bear arms. And unless the DOJ surprises everyone by filing an appeal in the coming weeks, that victory remains fully intact. For now, Judge Summerhay's courtroom in Lafayette, Louisiana, has quietly become the epicenter of a legal moment that may reshape how both amendments are interpreted for a generation. Key arguments and implications. So what does all this really mean? Not just for gun owners, but for every American who belongs to any political or advocacy group. The Reese v. ATF controversy reaches far beyond firearms. At its core, it asks how much information the government can demand from citizens simply because they choose to associate with a cause. And that makes this case a First Amendment issue as much as a Second Amendment one. If the original disclosure order had stood, it could have opened the door to something deeply chilling, the idea that the government can quietly compile lists of political members even when those citizens are exercising constitutionally protected rights. For many lawyers, that sounded eerily similar to the McCarthy-era loyalty investigations that the Supreme Court spent decades dismantling. The vacatur by Judge Robert R. Summerhays reaffirmed that line in the sand. Courts can't enforce constitutional protections by violating another constitutional protection in the process. The right to bear arms and the right to associate are both part of the same fabric of liberty. Tear one, and the others start to unravel. Legally, the fight now moves back to the substance of the case, the federal under-21 handgun sales ban in 18 U.S.C. 922b1. The plaintiffs will continue arguing under the Bruin text, history, and tradition test that there's no historical precedent for denying 18 to 20-year-olds the ability to buy handguns.
The DOJ, meanwhile, will likely contend that age-based restrictions are consistent with long-standing regulations. But philosophically, Reese v. ATF has already delivered its first lesson. Transparency and privacy can coexist, so long as the government remembers that liberty isn't licensed by the state, it's recognized by the Constitution. Here's the bottom line. The membership list order is gone, but the questions it raised still linger. Who gets to define the boundaries of your freedom, the government or you? I've spent years studying how small procedural rulings can reshape major constitutional principles, and Reese v. ATF is one of those moments. It reminds us that constitutional rights don't defend themselves, people do. As this case moves forward in Lafayette, Louisiana, the implications could reach all the way to the Fifth Circuit and maybe even the Supreme Court. So stay informed, stay skeptical, and most importantly, stay engaged. If you found this breakdown helpful, hit like, subscribe, and tell me in the comments, do you think the government should ever have access to private membership data in constitutional lawsuits? Until next time, I'm here to help you think like a lawyer and maybe defend like one too.